Hey everybody, Paul Rabelais here again. Another action-packed live stream. Got a lot going on here to tell you. It's a good one. This one's all about who you should select as your executor or the successor trustee of your living trust. We'll get into all of that, but essentially I want to break it down into 4 parts in this live stream. Live stream number 1, why this decision is so important. Number 2, what are typical executor or trustee duties? Need to know what need to know what those duties are, so you can say, okay, well, if they have to do this, then this would be the appropriate person to select as my executor. Number 3, I want to go over what are some of the traits of an excellent or an outstanding executor. And by the way, when I say executor, I might say executor or trustee. I might say executor. I might say a trustee. Essentially, what I'm talking about is there's an appointment that everybody makes when they get their legal affairs in order. And people who get their legal affairs in order will always have a last will and testament, and always in that last will and testament, and one of the reasons you have a will is to name your executor. Now, you may have that type of estate plan that many people do, where they want to set it up to avoid all the court and attorney involved probate. So in addition to their will, they'll have their living trust, which is essentially a will replacement, but you're setting things up in your trust, things that are in your trust when you die, avoid all the probate difficulties. So when you set up your living trust, you'll be the trustee of your trust during your lifetime, or you and your spouse will be the trustees of your trust during your lifetime, or the surviving spouse will be the trustee, but you'll designate after you pass away, or after you and your spouse pass away, if you're married, you'll designate what I'm going to call a successor trustee, who's in charge of all the things that we'll be talking about here this evening. So when people have that living trust plan, they designate a successor trustee. And in their pour over will, as I've referred to in many other videos, they'll also name their executor. If they don't have a living trust and they kind of just have a will, really the executor is the only appointment that they'll make of who handles stuff when they pass away. Sometimes I'll say executor or trustee. And when I say executor or trustee, I'm really referring to executor or successor trustee of a living trust. I might just say executor, and I'll distinguish those roles here throughout the live stream. Couple of rules. Reason we're doing it live is so that we can have some involvement with the chat. So I'll present some information for a while, then we'll take moving on over to the chat. We'll take a look at all those comments, experiences, questions. I suspect there'll be a handful of questions during the live stream, just because every probate is so unique, and every probate has so many different pieces and angles and steps that sometimes things go wrong, and the public, the heirs, they just want to know what's going on here. What's the rule? What should be happening? Is what I'm observing right based on this set of circumstances? So feel free to throw all that in the chat, even positive experiences that you have, maybe negative experiences that you have that other people who watch this video, either live or after when it's on YouTube, everyone can benefit from. So a lot going on here. Let's just jump in. So let me just a handful of comments on why this decision is so important. I will say I make videos. There's hundreds of videos on my channel, and I'll get these comments from people that are like, I'm like, I can't believe people are writing this. You know, people will write in comments, Paul, I'm involved in a probate. I haven't heard from the executor since so-and-so died, and it's been 4 years. Or Paul, so-and-so was the executor of an estate that I'm involved in, and the executor just cleaned out all of the accounts. Or some people will ask, Paul, can an executor just do whatever they want to do? And these are just crazy questions. And I realize there's perhaps 2 sides of every story. And if we talk to the executor, then there's a good chance we're likely to get a completely different story. But this decision is really important. Let me give you a little more background. I've been an executor just a handful of times. Family members, relatives, acquaintances, maybe between 5 and 10 times I've actually served in the position of an executor. I've been the attorney for the executor and heirs hundreds of times, maybe even 1,000 by now. So I've been right in the thick of it from the moment somebody passed away until perhaps months later, and in some cases years later, when the probate gets finished. And kind of my number one executor story, when I think about, what's one executor experience I can share? It's my own personal experience. When my father passed away a few years ago, then my mother passed away a few years later. They were married for probably 60 years or so, and they had 5 children. I'm the youngest of 5, and so in my parents' wills, they had named me and my sister the 4th of 5, and my sister was the type who went to their house every day, took care of everything for them. So my parents designated me and my sister as co-executors, 5 children, everything goes five ways equally. So when my father passed away, of course, I did all that paperwork, did all that legal work, but it really was fairly straightforward. The kids really weren't involved much because my mother was still alive and everything kind of stayed with her. And then she passed away. And that's when it's time for things to go 5 ways equally. And so I'm thinking to myself, okay, if there's one executor in the world who's going to be held to the highest standard of being an executor, it's going to be me, and I got to live up to that standard. So I knew exactly what I had to do, and I knew that there's many areas where probates get delayed months and years at a time. So I was going to just eliminate any possibility that there was going to be difficulty, stress, delay. Was going to make sure there was really open communication. And so really the day after my mother passed away, I had all our first set of court pleadings prepared. Me and my sister, we signed all the paperwork. We took our oaths that we'd faithfully perform our duties. I rushed to the courthouse, made sure all that paperwork was filed, checked with the courthouse every day to see if the will had been probated, more on that later, and to see if my sister and I had been confirmed as co-executors, more on that later. And probably within 15 minutes of the judge signing the initial set of court orders that we were, quote unquote, confirmed as the co-executor, and these letters testamentary, more on that later, had been issued. When that happened, that was about the same time that the death certificates were issued. So I collected the court orders, the death certificates, rushed over to the bank, of course, quickly got the tax ID number for the estate, quickly set up estate accounts, moved the funds into the estate account, went to the brokerage firm, moved the investments into the estate brokerage account, got made sure all the income tax filings were handled. That actually came later. But I was Johnny on the spot. I remember maybe a couple of days after my mother passed away, I collected all of the statements from financial institutions, put an email together with all the statements, all the latest statements, and all of the steps that we were going to have to follow, and when I was going to expect all of my other siblings to need to sign things and take action, put all that in there. Everybody was informed every step of the way. Yep, were there delays because financial institutions and brokerage firms, they just don't move quickly on these things. And you work with someone at a brokerage firm or at a bank, and they're like, well, I see there's this will, I see there's this court order, I see you have the death certificate, but I can't make this decision by myself here at the bank or here at the brokerage firm. I've got to send all this paperwork to the legal department, and we've got to wait on the legal department to approve it before we can start moving anything around. So yes, did it take a while, but months later, everything was resolved. All the relationships were still great with the 5 siblings, and got some compliments along the way there. So had an experience there, and we'll be talking a lot more about those executor duties here. But really, it's an important decision of who's your executor or successor trustee of your living trust or executor of your will. Quite frankly, because you've probably worked your entire lifetime just to build what you have, to just preserve what you have. I'm sure you've sacrificed. And so that executor decision that you make will impact directly not only how much of an inheritance your heirs will receive. It certainly will impact when they receive it. Is it going to take weeks or months or years, or in some cases, decades after somebody passes away before they receive an inheritance? And maybe even more important than the how much and when the heirs receive it, but also the executor's um, duties and their performance certainly has a direct impact on the future relationships of all of those parties who are involved in a probate. So what I want to do now, I want to go through and I want to define what are those executor duties, what are those trustee duties. Before I get into those duties, I've got to touch on what happens, because if there's someone who's an executor or there's someone who's a trustee of a living trust, it's because the person who died took some action. They wrote a will, they created a trust, they made a conscious decision to appoint somebody as the executor, maybe their spouse if they're married, maybe an adult child, maybe a friend, an acquaintance, a professional, maybe a corporate entity to be that executor or be that trustee. We'll get to all of that in a minute. But I can't get through this presentation without talking about what if somebody dies and they got nothing. They never signed any will. They procrastinated. They died before they were able to get around to it. And they still have an estate that needs to be settled. They never appointed an executor. They never created a trust and appointed a trustee. And so they've got a pile of assets. Who's going to handle all of that? So let's talk about that first, because the duties of that person are similar to executor and trustee duties. So when somebody dies with nothing, let's say Fred Flintstone dies with, he may have an IRA when he dies. He may have a couple of bank accounts, maybe a checking, maybe a savings, may even have a CD or two, may have a brokerage account that's outside of his IRA or outside of his retirement funds. That brokerage account may own some stocks, bonds, mutual funds, cash, may even own a business and likely own vehicles. And so who handles all of that? How does that get distributed to the heirs when Fred Flintstone dies? So typically what happens is, when Fred dies and everybody realizes, wow, Fred didn't take care of his legal affairs. He planned to get around to it, but you know what? He passed away and he never did. So I would say that the practical effect, and maybe the best set of circumstances, and let's say Fred died with two adult kids, in a very amicable and supportive situation. Those two kids who are Fred's heirs, let's say Wilma died years ago, his wife. Fred's two kids would likely get together and say, okay, we're the heirs of Fred, but we've got to follow some court steps. Our dad died without a will. And so ideally, maybe those two kids get some advice, and finally they realize, hey, one of us or both of us is going to have to step up and ask a judge to be appointed as the administrator. Some states may call it personal representative, but if Fred died without a will, let's call that person who settles Fred's estate an administrator. Again, what we're going to get to in a minute is if he had a will, he named an executor. If he had a trust, he named a successor trustee. But let's say Fred had nothing. So typically those two kids will get together and say, you know what, so-and-so lives in the same city as Fred. They can handle stuff easier. They've been handling, helping Fred with his accounts anyway. The two of them agree, okay, let's let Pebbles be the administrator. So Pebbles and Bam Bam, Fred Flintstone's two children, they get together and they're like, okay, we can't do anything until we get an administrator appointed. So they say, Pebbles, let's let you be the administrator. Now, this is not the administrator gets to pick and choose how much each of the two children inherit. This is really not a decision that has much financial impact. Although I will tell you, the administrator, the court-appointed administrator, is entitled to a fee that's payable from the estate, kind of right off the top of the estate, before the rest of the estate gets split between the two children. In many states, that's a percentage of the estate. Maybe it's 2 or 3%. Sometimes it's a sliding scale based on the value of Fred's estate. So there is a little bit of a financial benefit that could go to the administrator. For example, if somebody has a $2 million estate and the administrator's percentage is 2%, that's $40,000 right off the top that goes to the administrator. And then, the rest gets split between the two children. So I will also say that many times that administrator who is one of the children and one of the heirs will agree to waive their administrator compensation because they just kind of feel honored to do it. And plus they're inheriting half or a portion of the estate anyway. So anyway, those heirs often will get together. They'll kind of nominate someone to be the administrator. The administrator gets with the lawyers. The lawyers prepare a bunch of court paperwork. Hey, the heirs have all agreed that Pebbles should be the administrator. So all these court pleadings are prepared, asking a judge to appoint Pebbles or whoever as the administrator of Fred Flintstone's estate. So typically, especially if all of the heirs participate in that position, they all sign off on it, a judge will appoint that petitioner to be the administrator of the estate. Sometimes it's not a child. Sometimes it might be a co-owner of property who co-owns it with Fred, maybe a business partner of Fred, but often either the spouse or maybe one of the adult children. All right, so the judge signs the order. Okay, I'm going to sign an order here that Pebbles is now the administrator of Fred Flintstone's estate. And once that order is signed, then the courthouse employees issue what is typically called letters of administration. So that's a court document that says Pebbles hereby has the authority to handle matters on behalf of Fred Flintstone's estate. Now, Pebbles' job as the administrator of Fred's intestate probate, and I say Fred had an intestate probate because Fred died without a will. He died without a last will and testament. He died intestate, as opposed to Fred dying testate, which means Fred died with a will, and in that will he appointed an executor. So just wanted to go through that little step of an administrator getting appointed if someone dies with an estate and they have nothing. Now once they're appointed as the administrator, their job will be very similar to the executor's job if Fred had a will. Maybe the only difference between an administrator's job and an executor's job is an administrator ultimately is their role is to manage, administer the estate, and then ultimately at the end distribute the estate to whoever whatever state he was domiciled in. It's going to be Fred's administrator's job to make sure that the assets go to whoever Fred's heirs are under the intestate rules of the state where Fred was domiciled. So maybe Fred died and he had 2 adult children. Maybe he had another child, but that child died and that child had children. So there's laws in Fred's state that says who inherits from Fred because he didn't have a will. So that's the difference between an administrator's job, which is ultimately to deliver the assets to the intestate heirs, versus an executor's job, which is ultimately to distribute the assets to the heirs that are described in the will of the person who passed away. So now we can shift on to the executor duties, and I'm seeing some chat activity. Good. I can't focus on it right yet, but I love to see the activity in the chat. So now we'll focus on the executor duties. So each estate is different. I was trying to think today whether I've just been involved in hundreds of estates or has it been more than 1,000. I don't know, but it's at least been several hundred, and everyone is unique. Everyone is different. And I'm going to start with kind of the vague statement that the executor's job is generally they have a duty to move things along at a reasonable pace. Well, what things do they have to move along at a reasonable pace? Let's go through that. So, and before we go through the steps, let me talk about what's normal. Who's the typical person that gets appointed as an executor in a will? So I'd say it's and whether common is right or wrong, that's another discussion. But I'm just going to tell you what's common because I've read thousands and thousands of wills after people have died, and I know who typically gets appointed. And so now, whether that was a good appointment, that remains to be seen, and you don't even know until after the person passes away and they start performing or not performing their duties as the executor. But I'd say it's very common for a married person, if they write their will, they're going to say, I appoint my spouse as my executor. And then it's strongly advisable to name a backup to the spouse because the spouse may predecease the person writing the will. So it typically says something like, I name my spouse as the executor. I would say it's most common if the person writing the will has adult children to say, I name my spouse as my executor, and I name my adult child, list out the name, as my alternate executor. Could there be co-executors? Maybe. We'll talk about unique circumstances in a few minutes, but I would say that's most common. Does it have to be a relative? Doesn't have to be. It typically is. It could be a relative. It could be a friend. Some people say, I got 3 kids. And you know what, based on their kind of relationship stuff that's going on, I don't think it would be good to have my kids or to even have one of my kids being in charge of settling my estate due to the relationship dynamics that are involved. So some people will appoint an acquaintance, a friend, another relative, or a professional. But I'm here to tell you, I've read enough wills to know that most people appoint their spouse and an adult child as the backup. Okay, so the first job typically is kind of like the first job I told you a few minutes ago when my mother passed away, was they've got that executor very, very likely going to have to get with lawyers and court documents. The first round of court documents will be prepared because what has to happen when somebody dies with a will, there's a court procedure for getting a judge to declare that the person's will is valid. So some people think, oh, Dad died, I've got his will right here. He left his bank account to me. I'm just going to take this will to the bank and the bank's going to give me the money. No, the bank needs to see court documents. So the first thing that has to happen is it's really 2 parts to this first step. Court pleadings get prepared, and then if everything goes smooth, a judge signs a court order ordering that the will is valid and confirming the position of the executor. So in our case, Fred Flintstone died. He had 2 kids, Pebbles and Bam Bam. Fred wrote a will, left everything to his 2 kids, Pebbles and Bam Bam. He designated Pebbles as his executor. Fred dies. Pebbles and Bam Bam get with the lawyer. Court pleadings prepared, filed at the courthouse. Judge signs the order. Yeah, Fred's will is valid, and I'm confirming that Pebbles is the executor. Next thing they'll do is they'll likely get a tax ID number for the estate. So, of course, all of Fred's financial accounts, the tax ID number at the brokerage firm, at the bank, when Fred was alive, was his Social Security number. If Fred had a living trust while he was alive, and the living trust went and set up bank accounts and brokerage accounts, well, the rule is very clear. Fred's just to use his personal Social Security number for those trust accounts, because the revocable living trust, it doesn't file a tax return. It doesn't pay taxes. Everything just flows through to the grantor's personal return. So while Fred was alive, everything flowed through to his personal security number, Social Security number. But once Fred dies and now his assets are in the estate of Fred, well, all of these financial institutions are going to require that the estate have its own tax ID number. It's not a big deal. It can be applied for online and obtained same day. But once Pebbles gets confirmed as the executor, Pebbles is going to need that court paperwork. She'll likely also need Fred's death certificate to prove to the bank that Fred died, because they'll want to see it. And Pebbles will also need that estate tax ID number. Brings all that to Fred's banks and establishes I'm going to call it a temporary estate account. Just so you'll know that this estate account is not going to last for the rest of Pebbles and Bam Bam's lives. It'll last as long as what we call this estate is open. And likewise, if Fred had a living trust, upon Fred's death, Fred's revocable living trust becomes irrevocable. Now that Fred died, nobody can change the terms of that trust. Goes to the two kids equally. Pebbles is the successor trustee. Nobody has the right to change any of that. But when Fred's revocable living trust, tax ID number, his own social security number, dies, and then the trust needs its own tax identification number, employer identification number, whatever you want to call it. So that's always kind of one of the first things that we do is we get that tax ID number for the estate or the trust. And if Pebbles is the executor, she takes all that paperwork to Fred's financial institutions, likely opens up an estate account at a bank. And maybe even if Fred had bank accounts at 5 different banks, she'll go to Fred's 5 different banks with all of the approved paperwork, court order that Pebbles is the executor, Fred's death certificate, tax ID number, and those banks will all close Fred's accounts and write certified checks to estate of Fred Flintstone. And Pebbles is likely to establish one bank account at whatever bank and deposit all of those funds into that one temporary estate account. If Fred had some investments at a brokerage firm, then Pebbles will set up an additional estate account at the brokerage firm because the bank account can't handle securities, stocks, and bonds. Bank account, the estate checking account just handles the cash. So Pebbles will need an estate brokerage account at a brokerage firm, move the assets from Fred's individual account into the new estate account. So now Pebbles has a couple of estate accounts going on. She's got one at the bank, she's got one at the brokerage firm. And really her job is to pool all those funds together. She will start paying Fred's bills. Maybe he had some credit card bills. Maybe he had a car note. Maybe he still had a mortgage. So Pebbles has to manage all of that. Maybe his house still has utilities bills, has a cell phone, cable and internet that maybe Pebbles doesn't want to turn off. But with her court paperwork, she can go to all those third parties and say, here's the court paperwork where I am in charge of Fred Flintstone's estate. So she can request that if necessary, the cable company, close the account. The cell phone provider, close the account, keep the utilities on, pay the credit card bills. So Pebbles handles all of that. In addition, Pebbles is going to, I call handle all of the various assets that aren't just liquid assets like bank accounts and securities, stocks, bonds, mutual funds. She's probably also going to now deal with maybe a house, maybe some other real estate, some vehicles maybe that Fred owned, maybe a business or LLC that Fred owned. Not to mention all of the personal, kind of non-titled personal items that Fred had. Occasionally, people say, Paul, I'm the executor of my mother's will. She just died. She's got a lot of expensive stuff in her house. And my siblings are calling me. They want to go in the house and just start taking stuff. Is that okay? Well, it may not be. So if we got to get formal here, because your siblings aren't all going to be open and cooperative on everything, you really, as the executor, have a duty to preserve all that stuff. Maybe you need to change the locks to your mother's house so your siblings just can't go in there and clean out the house and take all of that stuff that everybody needs to say, hold on, let's take this slowly and do it the right way. So the executor has to handle all these things. Maybe they'll list a house for sale. Maybe they'll go, sell the car as the executor of the estate. So if they do sell the house, the executor typically finds the listing agent, if that's appropriate, signs all of the purchase agreements on behalf of the estate, attends the closing on behalf of the estate, Let's say Fred's house sells when Fred dies for $500,000. The executor attends the closing. At the closing, there's a check payable to estate of Fred Flintstone for $500,000. Pebbles goes and deposits that into that temporary estate account for ultimate handling of paying of bills and ultimately dispersing, remaining estate assets to the appropriate heirs. In addition, there may be some tax obligations that Pebbles, as the executor of Fred's estate, has to handle. So maybe a final income tax return. Unlikely unless Fred's estate is very, very large. If Fred died in 2024, if his estate was more than $13.61 million, then there would have been an obligation to file a IRS Form 706 federal estate tax return. Let's say in this case that wasn't the case, because it rarely is the case that an estate is required to file a federal estate tax return. So that's another story, another topic for another live stream. And so now you're probably getting an idea that Pebbles, as the executor of the Fred Flintstone estate, is collecting all of the assets. Hopefully they're communicating with the heirs. More on that when we talked about traits of an executor. But they're collecting all of the assets. They're dealing with debts, dealing with bills, dealing with how to handle the house, the belongings in the house, the vehicles. And so maybe Pebbles decides, boy, he had an old beat up car. I'm going to sell it. I think it would be appropriate, Pebbles says, to sell it for $3,000. She sells it for $3,000, collects that money. That money's payable to the estate. And then, of course, Pebbles deposits that into the estate account. So generally, that's Pebbles' role so far as the executor. In addition, the lawyer that Pebbles worked with is likely to prepare an inventory of, as of the date that Fred died, here's all of the assets that Fred owned, all of the legal descriptions of all the real estate that Fred owned, all of the various accounts that Fred had, all of the debts that Fred had. So a judge doesn't want to sign an order ordering that all of the assets of Fred be dispersed to Fred's heirs unless the judge has an idea of what assets exist and were they handled the right way. So towards the end now, Pebbles gets with the lawyer, prepares another set of court pleadings. Maybe all of the heirs sign off on that, and the heirs are petitioning a judge to sign a final court order ordering, and that petition will likely say something like, okay, this estate has been handled, the house has been sold, the car's been sold, here's the various accounts. The heirs are petitioning to ask a judge to order that remaining estate assets be dispersed to the heirs in the appropriate percentages or amounts. And then judge signs that order. Then Pebbles, as the executor, transfers all the estate assets. If there's a brokerage firm with or a brokerage account with 1,000 shares of Apple stock, she's going to see to it that Pebbles opens an account at the brokerage firm. Bam Bam opens an account at the brokerage firm, and the 1,000 shares of Apple stock that's in the estate account gets split up, 500 shares into Pebbles' account, 500 shares into Bam Bam's account. So that's how assets get dispersed. Maybe if Fred owned a business or Fred owned a home or real estate and they're not going to sell it immediately, the real estate perhaps may get transferred so that Pebbles and Bam Bam are each 50% owners in that real estate that was owned 100% by Fred while he was alive. Okay, so starting to see what an executor's roles are. There is typically lawyer involvement. There is court involvement. There's involvement from the lawyers of financial institutions, as you might imagine. Financial institutions are going to be somewhat reluctant to part with the money. One, they don't want to part with the money because they're in the business of holding on to money. But two, they're going to be resistant to parting with money because there's this risk that they may release funds to the wrong people. So they're really going to cover their tracks. And that's why all of all the involvement of all of these estate settlements, it all has to be run by the legal departments of the various banks, credit unions, brokerage firms, and they have to sign off, give their final seal of approval on the documents before assets can be dispersed to the appropriate heirs. All right, so again, all done. Lawyer involvement, court involvement. Is there sometimes delay? No question about it. Is there expense? No question about it. Executor, heirs, hire lawyers, court fees. It's all just, part of dealing with a probate when somebody dies with assets in their name and they're frozen. And so courts are required in order to enable for the heirs to receive assets. All right. So what I want to do now, though, is I want to talk about the distinction between an executor's duties and a trustee's duties. So quick background. Fred Flintstone died. He had assets in his name. He had a will. His will said, I name Pebbles as my executor. His will said, I leave my estate equally to my two children, Pebbles and Bam Bam. And so he dies. Pebbles and Bam Bam kind of get lawyer up because they need to, because all of these probate procedures are really complicated. And I've seen too many people, I haven't seen many people, but I've seen a few attempt to do these court pleadings on their own. And if they write one word the wrong way, then by the time these court orders get to the financial institutions lawyers say, well, no, this court order wasn't written the way we need to have it written. Go back and start over. And so that happens sometimes when people try to do this stuff themselves. But I think 99% of the people realize they can't do themselves. They don't have the skill. And so they hire lawyers who have experience and know how to follow the process. Okay, so I want to talk about the differences between an executor of a will and a successor trustee of a revocable living trust. Up until now, we've been talking about Fred had a will. He had assets in his name. They were frozen when he died. Fred's heirs hired lawyers, followed the procedures, filed the will at the courthouse. Judge appointed Pebbles as confirmed that Pebbles was the executor, declared that the will was valid. All the court inventories of assets in the court, in the rules of the court were prepared, submitted to court, final court petitions, judge signs orders ordering estate assets to be dispersed to the heirs. Okay. Now let's look at it a little bit differently. Let's say Fred had his revocable living trust, and he did that because he wanted Pebbles and Bam Bam to be able to settle Fred's estate without court and lawyer involvement. So Fred created his revocable living trust. His trust said when Fred dies, because it's a trust, he needs to name a trustee. So he names Pebbles as the successor trustee. Fred is the initial trustee because this trust is active during his lifetime. So Fred maintained the control to be able to do whatever he wanted to do with the trust assets while he was alive, including serving as the trustee of that trust. But Fred said when he dies, he named Pebbles as the successor trustee to handle the trust settlement and make sure things went equally to Fred, Pebbles and Bam Bam after Fred died. So Fred transferred his home to his trust. He transferred his bank accounts to his trust. He transferred his brokerage account to his trust. So instead of all of Fred's assets being titled in the name of Fred Flintstone, they were titled in the name of Fred Flintstone as trustee of the Fred Flintstone Trust. And so again, Fred's like, boy, when I pass away, I want to make things as easy as I can for my two children. I don't want them to have to go through probate. Let me set up a trust, name Pebbles as the trustee when I die, make it as easy as I can for her to be able to disperse everything 50-50. Okay, so now Fred dies with his living trust. What are Pebbles' duties as the successor trustee of Fred's living trust? Very similar to what those executor duties are, but Pebbles, as the successor trustee of Fred's living trust, can perform those duties without lawyer and court involvement. So she gets a tax number. She goes online with the IRS because, again, once Fred died, his revocable living trust always used Fred's Social Security number as the tax ID number for the trust, because that's what the IRS rules say to do. But when Fred passed away and Pebbles is the trustee and Fred's trust becomes irrevocable, the trust needs its own tax ID number. So again, apply online, no big deal there. If it's not applied online and done manually, it's done through or at least even if it's done online, it's done through the preparation of a IRS one-page form called Form SS4. It's an application for a tax ID number. Could be called you could call it a tax ID number. You could call it an employer identification number. I kind of like tax ID number because employer identification number implies that the estate is some kind of employer, which it isn't. So I call it a tax identification number. So Fred dies with his living trust. Pebbles is the successor trustee. She gets that tax ID number. She realizes that the living trust has accounts at Fred's bank, at Fred's brokerage firm. So as soon as she gets Fred's death certificate, she takes the tax ID number, Fred's death certificate, perhaps a copy of the trust that shows that Pebbles is the trustee now that Fred has died. She takes that to Fred's bank. She takes that to Fred's brokerage firm. And upon their review of the documents, they will allow Pebbles to set up a new trust bank account and a new trust brokerage firm account using the new tax ID number for the new irrevocable trust now that Fred has died. And again, no court orders were necessary. And then out of that trust account, Pebbles has a responsibility to pay Fred's bills if he had any, pays funeral expenses, other administrative expenses. She may have to hire accountants and lawyers to do certain things, maybe not. But whatever expenses of the estate settlement, whatever bills, maybe Fred had some credit cards, she'll pay those, or at least work with the credit card companies to get that balance down to zero, whatever that takes. And then ultimately she'll disperse the trust assets to the trust beneficiaries. So if there's a trust account at the brokerage firm and it had 1,000 shares of Apple stock, again, Pebbles will make sure that Pebbles sets up an account at the brokerage firm. Fred sets up an account at the brokerage firm. And then Pebbles, as the successor trustee of Fred's living trust, can direct the brokerage firm to move the assets from the trust account, 500 shares into Pebbles' account, 500 shares into Bam Bam's account. Now, maybe Pebbles and Bam Bam have their own investment accounts at different brokerage firms, and they want to move it. Once they receive their shares in their own account, they can do whatever they want to with it, including sell the shares, move the shares to another brokerage firm because they have another financial advisor that they want to manage all of that. So the idea here is, and this is why so many people set up living trusts, if you leave your assets in your name and you write your will and you name your executor, then when you die, everything's frozen and your executor really can't do anything without getting lawyers and judges and courts involved, because court orders are necessary before third parties will allow for the release of the assets. All of that takes time, effort, and money, and it's a hassle. So many people out there want to prevent their survivors, their loved ones, from having to go through the court and attorney involved process. So they set up their living trust, name the same person that they would ordinarily name as the executor. They name that same person as the successor trustee of their living trust. But when Fred dies, things typically happen a lot much faster when a trust is settled, because third parties don't require court orders in order to release the assets, and things move quicker without that lawyer and court involvement. Now let's move on to what are some of the traits of an excellent executor or successor trustee of a living trust. There's 5 or 6. The first one I'm going to say is that trustworthiness. The executor of your will or the successor trustee of your living trust, particularly even the executor of your will, they're going to have their hands typically on a large pile of money. Yes, does an executor need court authority to do certain things? Yes, they do. However, an executor is going to establish estate accounts. A trustee is going to establish trust accounts, and they are the signer on those accounts. So, that may cause you to ask the next question. Well, Paul, if Pebbles is the executor and there's an estate account that has $1 million in it, and she's the signer on the estate account, can she just go take all the money? So I'm sure it has happened many times before. And so, is she legally entitled to do that? No. And she's bound under this fiduciary responsibility to work on behalf of the heirs and manage things prudently, like any other executor would reasonably handle things, make sure assets ultimately get dispersed to the heirs. But she does have her hands in the cookie jar. And so you have to have a trustworthy executor or trustee, somebody who's not tempted to do something not only wrong, but in many cases criminal. Another really good trait of an executor is them being an excellent communicator. When Fred died and he had a $2 million estate, all of a sudden, Bam Bam, as weeks go by and months go by, little Bam Bam starts to get nervous. He's like, where's my money? I don't have access to it. I haven't seen it yet. Pebbles is the executor. And what's taken so long? I'm wondering if Pebbles is doing what she's supposed to do, or I'm wondering if she's mismanaged anything. And I'm starting to wonder if maybe she's using these assets for her own benefit. So Pebbles, the excellent communicator, once Fred dies, may say something like, all right, let's maintain a group email. All of us, everything I do, every question that gets asked, let's have a group email, maybe even with a lawyer that's involved. Let's disclose all of the statements. Let's have a plan for getting things done. Let's let Bam Bam know what that is. So he knows that if weeks and months go by, no problem, because we've got a plan and we're just following a plan and everything's being disclosed every step of the way. So someone who's an excellent communicator, who maybe Bam Bam calls Pebbles and Pebbles isn't calling Bam Bam back for 2 weeks. And now all Bam Bam's nervous. Should he hire his own lawyer? Should he sue Pebbles? So, ideally an excellent communicator can, all those shoulders tends to go down. Everything's okay because I've got an executor. I'm sure I'm an heir and I'm not the executor, but I've got an executor over here who's has excellent, communication skills and is letting us know what's going on every step of the way. Also, it helps for an executor to be knowledgeable. When you're dealing with estate, you have to understand finance, investments, real estate, tax. All that comes into the role of the executor. And I've had an executor who really didn't understand what shares of stock were. And so that's a problem. Or didn't really understand what a mutual fund was, or didn't really understand what a limited liability company or an S corporation was. And so it just creates risk that something might be missed and a mistake might be made. Also detail oriented. If you have an executor who can manage details, oftentimes there's lots of accounts, there's lots of bills, there's lots of creditors, there's lots of heirs that need to be managed. And if you've got somebody who can kind of multitask and handle several different details at once, that helps. Also really important that executor be what I say impartial and fair. And I want to qualify what I mean by fair. So, obviously an executor can't say, okay, let's see, the will leaves everything to the 3 children equally, but there's this grandchild who just doesn't have a car. So as the executor, I think I'll just turn over dad's car to this grandchild who doesn't have one. And so while that might kind of sound fair because the grandchild doesn't have a car, what I would do, as an executor, I'm always like, or as the attorney for the executor, I'm always like, okay, if this thing made its way to a judge because there was some kind of conflict and a judge had to rule on who should get grandpa's car, well, let's make sure that car goes to the people that it would go to if a judge ruled on it, which would be the 3 children. Now, if the 3 children want to get together and they want to donate that car to the grandchild who has no car to go to school or go to college, great. But first things first, it's got to go to the people it's supposed to go to. That's that impartiality. So, and when I say fair, an executor doesn't get to change the terms of a will or a trust. So maybe dad said, I want 30% to go to this child, 30% to go to this child, and 40% to go to this child. And if the executor looks at that and says, well, that doesn't seem fair to me, I think it's best that we just divide everything up three ways equally. That's what would seem fair. That executor says, well, no, while you think you're determining what you think is fair, but your father already determined what was appropriate based on the terms of what he created. So you do have to be fair and impartial, but you do have to abide by the rules. All right. Also, experience helps. Most people, many people who I've worked with, as and they've been the executor of an estate, I would say maybe 80 to 90% of the time, they'd never been an executor before. They got no idea. They don't know. They know in general what they're supposed to do, but they don't know the specifics. So if you can appoint an executor who's maybe done it 2 or 3 times before, certainly doesn't hurt. So experience is helpful. All right, now let me go into the last part 4 of 4, and then we'll hit the chat here. Is what are some of the unique or special circumstances that really need to be discussed in how do you select an executor? Okay, so one is, should there be co-executors or co-trustees? And I would say, all else being equal, no. Just because, I'll give you a story, and I'll use a personal story. We had a very good family friend, and she didn't have children. And she named my wife and my wife's sister as co-trustees of her trust when she died. Well, she passed away. We get the tax ID number that we need, and then my wife and her sister go to the bank to open a new trust bank account. They go to the brokerage firm to open up a new trust brokerage account. No court orders or anything, and that's fine. And so the bank tells my wife and her sister, okay, we got all your paperwork. We have everything we need. Let me submit it off to legal. We'll let you know. Never heard from them. And so we keep calling and we keep calling. And then finally we hear the bank and the brokerage firm both tell us, no, we're not going to accept this paperwork because we don't like to have to work with 2 people together and settling an estate. We'll only work with 1. So then we had to go through a scenario where my wife's sister had to resign as the trustee after they didn't tell us that for a month or 2. And I'm the probate lawyer. I'm supposed to be the one who gets things done very, very quickly. And even I had ran into a situation. So the co-trustee had to resign so that my wife could serve as the sole trustee. So for that reason, I'm not saying don't do it. If you are in a situation where you feel like, boy, the only way this thing could work out is if I have 2 co-executors or 3 co-trustees, then do it. But just realize there may be issues, or you may even want to go to your financial institutions and ask them, hey, if I pass away and I've got 2 co-executors or 2 co-trustees, are you guys going to enable them to open new accounts as co-executors or co-trustees? Will you work with the both of them? And some institutions will say sure, some will say nope, and then you can make decisions accordingly. But all else being equal, maybe name one of them as maybe talk with them and say, look, I think it'll be easier to get things done if I name one executor and then maybe a backup, or one trustee and then a backup. So let's just figure out who could be the one and who could be the backup. Not that I'm trying to be partial, but I'm just trying to make it as easy as we can so that you can get things done when you need to get them done. Another issue, we haven't talked about it this evening, is the corporate executor or the corporate trustee. All the large financial institutions, they also have their corporate trust company. Don't see it a lot. Maybe should see it more than we typically do. But it's for those people when you're like, I don't want my spouse, or I'm not married, and I don't want my kids to be the executor. I don't want my kids to be the trustee. I don't have an acquaintance, a friend. Maybe they'll talk to me and say, and I'll say, I don't want to be the trustee. I don't want to be the executor. Perhaps I'll be the attorney for the executor that you name, and I'll guide them through the whole thing. But, lawyers typically are in the business of providing legal services. Accountants do their accounting thing. Some people say that, oh, sure, I'll just pick my accountant or my lawyer to be the executor. But when those people are appointed as trustees and executors, 99 times out of 100, it's a one-off thing for them. And so, and then sometimes people will select a corporate executor. Yeah, if you name a corporate executor, is it a little less, personal? Yeah, it is. Do they charge, fees? Yeah, they do. So, but some people take that into consideration and say, no, I would want there to be professional oversight, professional management. These corporate trustees, that's what they do. They have the system set up to be able to do it. Yes, could it be somewhat impersonal? Yes, it may be, and maybe that's okay. So just realize that's an option. Also, I mentioned it briefly earlier, the whole aspect of compensation for the executor or the trustee. It's a little better defined for the executor than it is for the trustee typically. So when Fred Flintstone dies and he's got all his assets in his name and he has a will and he names Pebbles as the executor, there's some state law that dictates exactly what that executor compensation will be that Pebbles is entitled to. Sometimes that number can get pretty hefty for the larger estates, and the executor is entitled to a percentage of the estate. Might be 2%, 3%. And so sometimes that can be a little iffy between Pebbles and Bam Bam. Bam Bam's like, what are you doing, Pebbles, taking 3% off the top when we're splitting everything 50-50? So can be a concern. Trustee compensation, there typically isn't anything like there is with statutory executor compensation. Typically, trustee compensation, Fred has his living trust. He names Pebbles as the successor trustee. There isn't a statute that we can look at to calculate the dollar amount of compensation that Pebbles would be entitled to. It's a little more vague. Most trust codes say that trustee compensation must be reasonable. Maybe Fred addressed it in the terms of the trust instrument. Maybe he said, I request that an individual trustee serve as trustee without compensation. So Pebbles wouldn't be entitled to any compensation, but she's a 50% beneficiary, and that's okay. So just be aware that that's an issue when appointing an executor. In many cases, when it's perhaps a surviving parent dies, one of the children is named as the executor or the trustee. Oftentimes, that child, even if they're entitled to compensation, will say, no, I'm going to waive the compensation. I don't want it. I'm honored to be named as the executor. I'm honored to be named as the trustee. I'm going to waive it, and let's just leave everything to the heirs in equal amounts or whatever the documents might provide. Now, I will tell you, sometimes executors start out by saying that, and then once they go through 9 months of they're like, I'm changing my mind. I earned every penny of that 3% executor fee I'm entitled to, so I'm going to get it. So just be aware that there's some compensation issues. Also know that, when I see somebody email me or even comment to a video and somebody says, well, Paul, I haven't heard from the executor in 4 years. My dad died. I know my dad was a multimillionaire, and he named my sister as the executor, and she won't return my phone calls. She won't return my emails. I don't know what she's doing. It's been 4 years. I'm like, dude, get yourself an attorney, because an executor has the responsibility to communicate with all of the beneficiaries. They also, upon a request, can be required to prepare accountings. What were the assets when the person died? Where are the assets now? What has been all of the income and expenses of the estate? What are the assets now in the estate? So heirs and beneficiaries do not have to be left out in the cold. They can request and be entitled to receive information and accountings. And if they request it and don't receive it, then they can request that perhaps the executor get removed, and then somebody else be appointed as the executor or trustee of a trust. So there is some recourse if you genuinely feel like, hey, they're not doing their job, they're not communicating, they're taking longer than a reasonable person would take to get this done. There is recourse, and it can vary from state to state. All right, so what we're going to do here in a minute is we're going to go to the chat, and we're going to look at what you did and take it one by one. Hopefully the chat is appropriate and worthy of some more discussion, but I will sum it up by saying this executor / successor trustee decision is a significant decision that not only impacts how much and when people inherit, but significantly can impact the relationships of those people that you leave behind. And so I've seen it many times where a woman will talk to me and she'll say, Paul, when my mom died, my brother was the executor, and because of some things he did or didn't do, I haven't spoken to him since my mother died, and I'll never speak to him again. And so that's the real terrible outcome of appointing the right people or appointing the wrong people to serve in these roles. You can really, not directly, but indirectly, you can kind of take an action that leads toward destroying relationships, which is really the worst thing that can happen. Okay, so now we'll move on over to the chat, and I like to go fast, and let's do it. So, hey, Shane, of course I said Larry. Larry's the MVP. We see him just about every time, if not every time. Always great to have Larry on the live stream. Emily, how come your parents didn't have a living trust? Just a will. That's it. I was wondering if somebody was going to ask me that. And good question. So, the reality of it is they weren't real sophisticated. And if there's anybody who can get a probate done and not have to deal with not having to kind of convince them on and educate them about a living trust and convince them that they need to retitle their assets into the trust, I kind of just didn't feel like I didn't want to burden them with that, especially as they got older. And so I was like, you know what? They'll just leave everything in their name. I got the probate under control. If anybody can get one of these done quickly and efficiently, it's me. So great question. And that's just how it turned out. Maria, how long did it take for the will to go through probate? So I filed the will at the courthouse probably 2 days after my mother passed away. Because I know everybody, and I can, if anybody can kind of get things done, so within a couple of weeks, the judge had signed the appropriate court orders. Then about the same time we got the death certificate, we're able to open up estate accounts, already working on the final court orders. I just demanded that, I had 5 siblings or 4 siblings. And I was like, look, guys, I'm sending you paperwork. It's coming. And as soon as you get it, get yourself in front of a notary, get it signed, get it back to me. Because if one of you has a delay, it's going to delay us all. So I knew the system, and I got it done as fast as I could. And so maybe 3 or 4 months, it was all finished. So good question. Larry, I was a successor trustee after my mom passed. She survived my dad. We sold the house and car after my dad passed, had me a signer on a checking account. So maybe your last point there, Larry. You were a signer on her checking account that was in her name. I call that a lot of kind of a hack that many parents take advantage of. So a lot of lawyers out there on YouTube or TikTok or whatever say, don't ever add your child as a signer on your bank account. But I know in reality, people don't take that advice because in their mind, it just makes sense. Mom says, I'm 85 years old. I might start slipping. I want my son, Larry, to be a signer on my bank account. So while I'm alive, Larry can look after and sign my checks. And both when I pass away, he'll have access to my account and it won't be frozen. So I can't argue with that position. So it looks like that's what happened here, Larry, and it worked out great. Chris, what's the best trust to set up in New York to avoid probate? It's the same kind of trust that everybody around the country uses to avoid probate. It's called that revocable living trust. In fact, again, this is not a commercial for my national law firm, but I do have a national law firm. We've helped a lot of people in New York, Florida, Tennessee, Texas, really everywhere. And so in the description of the video, you can click on a link, request a Zoom meeting with me. We'll kind of talk about what your estate might look like, how to design it, and what's the easiest way to get all that set up. So feel free to check that out. And Alate, of course, Ann here with my favorite emoji with the happy hands. Casey, hey, Paul, asked for a buyout from an inherited property in trust, 5 equal shares. My buyout request was ignored, and now the trustee is proposing to sell it to my sister for 1/2 of fair market value. So that's one of those, Casey, not to pick on you, but I don't get it. So not that there's, another side to the story. There probably is, but that's just, if it happens that way, that's just a kind of gross, inappropriate performance of an executor or trustee's duties. So a trustee has this responsibility to get the most that they can for all of the trust beneficiaries. Looking at the words of your chat there, if you offered to buy a trust asset for fair market value, and the trustee says, no, I'm going to sell it to this other person, even if that person's a beneficiary, for 1/2 of fair market value, I would be very nervous if I was that trustee and did that, because that trustee is going to be accountable. Laquita, good evening, Paul, from Jacksonville, Florida. I have a brother in Jacksonville. Maybe you know him. KC says the way the other 4 keep the property at a deep discount and I'm out. Isn't this self-dealing? Yep. Good point. And so it is a breach if it happened that way. And I got to go. We'll watch the replay. All right, Ann, see you next time. Love Sunshine. Hello. Hope this finds you well. I'm confused. Not sure if we need a trust as we have a will. So maybe to eliminate confusion, you just need to have a really good conversation with somebody who can really guide you through out of that pros and cons and help you make a good informed decision. That's all anybody where you get help. That's all we want your professional advisor to do, is enable you to make an informed decision. So that's what would be required there. Jackie, our lawyer, said since it's a small estate, we can do it online. What site do we go? So you just have to Google it. I don't know. Anybody, hello, Paul, can I designate my 9-year-old grandson as beneficiary of my bank account? That's not a good idea. So if you designate your 9-year-old grandson as your beneficiary of your bank account, maybe your bank offers payable on death bank account. Problem with designating a 9-year-old as a beneficiary, perhaps on a POD, payable on death beneficiary, is when you pass away, even if that 9-year-old grandson has parents right there with him, the bank won't allow a minor to open an account like that when they inherit. So what's going to happen is the bank's going to see, we need a court order telling us who the legal guardian of that 9-year-old grandson is. And yes, I realize the 9-year-old probably has parents, but still, when a 9-year-old is a beneficiary of an account, the financial institution, and you can go ask them, likely is going to say, we need a court order. So if you do want to leave money for a 9-year-old, really, it takes a little bit of effort now, but what you do is you set things up so it goes, when you pass away, to a trust for the 9-year-old. Maybe designate another family of yours, if it's appropriate, maybe a parent of the 9-year-old as the trustee of that trust. That way, that trustee can then set up the account, manage the assets in the account until the trust says the 9-year-old can handle it themselves, maybe at 21 or 25 or something like that. Could depend on how much money it is. Roast beers. My dad died without a will, and my sisters and I agreed to let my uncle be administrator. He said if we didn't agree to give my dad's GF, girlfriend, $50,000, he'd contest everything, and he did. We're in year 3 fighting him for our money. Interesting. So it sounds like, the girlfriend. So when somebody dies, you're talking about Roe Spears, uncle to be administrator. So in my thinking, since you use the word administrator, your dad, oh yeah, obviously first statement, your dad died without a will. So a unmarried girlfriend, when somebody dies intestate, they're entitled to zero. So good luck with that, but 3 years. Maria, 28, what if all the bank accounts are over 250,000 cash? It's smart to put that excess cash into one estate account at the bank because the amount is maybe. Less concern here because the estate account is a temporary account. When you open an account at the bank and you're 60 years old, that account may exist for the next 30 years. I'm not saying that the bank can't go broke during the 9 months while the estate account is open. But less concern about that. Maybe talk to the bank about that. The accounts are all going to be in the same name. So good question there. I really don't have a good answer for you. Casey, Roe, that's crazy. AJ, my home is paid for. I have 2 children. Everything I own other than my cars is 50-50. My son is my executor and lives with me. What will he need to do to remain in the house? So good question. Your son is the executor. That doesn't really give him any more right to remain in the house. The concern is the house is an asset that goes 50-50. So when you pass away, he's going to have an agreement with his sibling, and either the sibling who also owns a 50% interest in the house is just going to have to let is it son? Yep. Let your son live in the house that they own 50-50. Maybe your son uses some other funds that he inherits to buy out his siblings' 50% interest in the house. But there's going to have to be some agreement between the son and your other child if the assets go 50-50. All right. Thank you so much. Fioralba loves the show. Fantastic. Love having you on the show. Roe, yes, it's been heartbreaking. Yep, that's a tough one. AJ, does the executor need to go to court, and can the lawyer? Yeah, I mean, it can vary state by state, but I would say in general, the lawyer does all of that. There might be some states that may require an executor to make an appearance. And certainly if anything gets contested or any of that mess, then the executor may have to appear with the lawyer. But typically the lawyer does all the filings, and thanks for all that. You're welcome for KO, Larry, Paul. My advocate was an online estate planning document creation business that was acquired. It appears to have been acquired. So I can't speak for Origin. They did acquire my advocate. I understand they're going to release it in coming months. So that's what's going on there. Johnny 5, what happens if Pebbles ends up in jail at the time of Fred's passing? Would she be able to handle the executor tasks, or would Bam Bam automatically take over those tasks? Well, that may depend on what Pebbles is in jail for. So if an executor is in jail, that's a problem. So I'm wondering, did they commit a crime like theft or murder or something that probably means they don't have all of those excellent traits of an executor? What may happen is Bam Bam would file a petition at the courthouse and say, look, and in that petition, basically it would say, Judge, Pebbles is in the slammer. She's no longer capable of performing her duties as the executor. Judge, I'm asking you to remove her as the executor. And Bam Bam says, Judge, I'd like you to appoint me as the executor. So that kind of arrangement would happen. Whether it would be successful would probably depend on the circumstances, but good question. Virginia, if a bank account says POB, does it have to go into a trust? No. So Fred Flintstone may set up his bank account and he fills out a POD beneficiary designation form at the bank, payable on death, to Pebbles and Bam Bam. So when Fred dies, Pebbles and Bam Bam get Fred's death certificate, go to the bank, and the bank, releases the funds to half to Pebbles and half to Bam Bam. Now, sometimes, especially if Fred says, when I die, I have some heirs and I would want their inheritance to be managed over time. Fred may name his living trust or may name some other trust as the POD beneficiary. So when he does die, it does go to a trust because that's what Fred wanted, but it doesn't have to go to a trust to answer your question, Virginia. Great question. Jackie says Roe is the reason why he thinks girlfriend should get the money. Same question I'd ask Jackie. So Roe, let us know why the girlfriend thinks she's entitled to money. Maria, no, Virginia does not. You're welcome. Virginia, Roe, Jackie, he feels that she deserves something. My dad told me right before he got sick that everything went to his $3. Okay, so what makes her feel? I mean, does she deserve something because she was his girlfriend? And the estate settlement law doesn't work that way at all. Nobody is entitled to inherit an asset because they feel like they deserve something. It all is based on law. So, but they dated 5 years ago, right? Sorry, it's a lot of responsibility for a 3-year-old. Roe, so he's refused to release him. I got a lawyer and filed. Okay, good. KC, can I ask ballpark figures for lawyer Roe right now? 10,000. A lot of paperwork stuff in the last 3 years. So good. We got some communication back and forth among the chat members. So a lot going on there between Roe and KC. I'm going to keep going. Maria, what do you mean, KC, that your mom has your uncle as a signatory in your bank account or that he is an heir, i.e. POD? Maybe you can clean that up, KC. So keep going here. Go see some new names here. Flower, Virginia is holding my mother hostage. KC, I'm shocked at how greedy family members get. My mom and dad would be sad. Maybe that's the best statement of the whole day. So sometimes I think it was, if you're old like me, you remember Dear Abby, who her famous quote is, if you really want to get to know someone, share an inheritance with them. So there's a lot of truth to that. Okay, we got some duplicating messages. Bradley, can money be taken out of a trust while the grantor is still alive to buy a home with? So yes, if Fred Flintstone set up the Fred Flintstone Trust and his accounts were in the Fred Flintstone Trust, the Fred Flintstone Trust likely says that Fred can do whatever he wants to with all of the trust assets for the rest of his lifetime. So if he wants to remove assets from the trust account, no problem. If he wants to buy stuff, sell stuff, give stuff away, no problem. It's all completely controlled by Fred. It's just titled in a way so that when Fred dies, all the probate's avoided. All right. Lot going on here. Lot talking back and forth. And plus, we've been on here for an hour and 17 minutes. I think a lot of people chatting back and forth with each other, which is great. By the way, this leads me to let you know that I'm building a different community on a different site where we'll be able to have people on a Zoom call and be able to see people's faces, fewer people on a call, be able to have more community involvement. More on that later, but for the next 5 days, I'll continue doing these YouTube live streams for sure. They're already scheduled. Check the live tab on my YouTube channel. Chuck says, how difficult do brokerage accounts make it for successor trustees to take over on incapacity of grantors? Good question, Chuck. First thing they're going to do is they're going to look at the terms of the trust instrument. So does the trust instrument say if Fred dies or becomes incapacitated, then Pebbles becomes the trustee? It probably does say that. And then if it says that, does it define incapacity? So that's the first thing you look at, is how does the trust, if at all, define when Fred becomes incapacitated? It might say when a doctor signs an affidavit that Fred's incapable of handling his affairs. It might say when 2 doctors sign affidavits that Fred is incapable of handling his affairs. It might say when a majority of the beneficiaries all get together and sign statements that Fred is incapable of administering his affairs. So that's the first thing a financial institution would look like, is what's the standard for incapacity, and has that standard been met? And I would say that's the main thing. Once that's done, and sometimes trust instruments leave the definition of incapacity vague, that's probably when financial institutions or brokerage firms are going to get nervous. So good question there. But I will say it's often easier for a successor trustee to take over a trust account when the settlor becomes incapacitated, as opposed to that account being in an individual's name and then the power of attorney agent. Brokerage firms are real reluctant to use kind of power of attorney forms and give people authority. A lot of brokerage firms have their own durable power of attorney form, and they won't honor a power of attorney unless their own form. So just be aware of some of those issues there. Okay, Lynn says, if husband dies with trust, goes straight to me, his spouse, then I do trust for my only daughter. So, yeah, I mean, a couple of different ways there, Lynn Snow. Sounds like husband has his own trust as opposed to you and husband having a joint trust, and it could be either way, but sounds like with what you're writing, husband has his own trust. He says when he dies, all of the trust assets go to you. And then, yeah, you do a trust to leave things to your only daughter. So that sounds like that's right. You wouldn't want to know more. Lots and lots there. Okay, Flower, doing a lot going on there. And I just, and you're welcome, AJ. So y'all be safe too. And Larry, thanks again for being on, Larry. Always enjoy your chat and your participation. Sarah says she knows several Larrys in Bakersfield. Well, the best Larry in Bakersfield is the one who gets on these live chats for sure. All right, so we'll wrap it up. Obviously, this will be recorded next 5 nights, 6:30. If you're watching live, feel free to check me out, participate in the chat. We had a good one this evening. You'll have a great rest of the evening. We'll see you next time.